हेलो एवरीवन, वेलकम बैक टू माय चैनल लोमन एंड टीम। आज की इस वीडियो में हम कवर करेंगे इंडियन पार्टनरशिप एक्ट 1932 की इंट्रोडक्शन, मीनिंग एंड एसेंशियल्स ऑफ पार्टनरशिप एक्ट। मैंने अपने खुद के नोट्स बनाए हैं और बड़ी ही इजी वे में पार्टनरशिप एक्ट को डिफाइन किया है। बिना टाइम वेस्ट किए हुए चलिए स्टार्ट करते हैं। इंडियन पार्टनरशिप एक्ट 1932, इसमें दो बातें हमें याद रखनी है। पार्टनरशिप एक्ट इज एनफोर्स्ड इन 1 October 1932, but section 69, which is related to the fact of non-registration, is come after 1 year, that is 1 October 1933. The introduction of Indian Partnership Act is Partnership Act 1932 is applicable whole of India and it is based on English Partnership Act 1890, and before enforcement of whole provisions is comes under Indian Contract Act 1872, which is very wider act. Then two different act has been formed. First one is the SOGA, Sales of Goods Act in 1930. Second one is the Indian Partnership Act 1932. Then what is the meaning of partnership? It is mentioned under Section 4 of Indian Partnership Act. Partnership is relation between persons who have agreed to share the profit of business carried by all or any of them acting for all. Persons who are entered into partnership pays. Individually they are called the partners, collectively they called the firm, and name under they carried their business, it is called the firm name. Then what are the essentials of partnership? First is the agreement. Second is the association of the two or more persons. Then there must be a business. There must be a profit. Fifth is the mutual agency. First is agreement. There must be an agreement in the partnership and it is different from the Hindu undivided family. For example, there are the three members in the Hindu undivided family and they contribute 20,000 rupees. Then family members, they are not coming to the agreement, then they will not the partners. Then for example, there are the three partners A, B and C. Then the child of A will not be the partner under the partnership. Then agreement is of four types: written agreement, oral agreement, express and implied agreement. Written and oral we understood. Express is that which is by conduct, for example by signing the document. Implied agreement is that, for example, the partner say yes but they don't sign, it is the implied agreement. Then who become the member of the firm? First is the individual become the member. Second is the company, who is the juristic person or the artificial person. Then the individual of the partnership firm or the member of the partnership firm. Then fourth is the karta. Hindu undivided family will not become the member of the firm, but only the karta can become the member of the firm. Then there is a famous case, Dhuli Chand versus CIT in 1956. In this case, it is held that partnership firm is not the legal person and it can't enter into the partnership. Second is the association of two or more persons. Before the 2013, there are the two categories, banking and non-banking. Under banking, there must be a maximum number of persons 10, and under non-banking, the number is 20. But after 2013 amendment of Companies Act 1956, the maximum number will be 100 of both the categories. Then according to the rules under company miscellaneous rules 2014, according to these rules the maximum number can be 50. Third essential is the carried out of business. There must be a trade, profession or the occupation which is carried. There must be a lawful business. There is a case Gopiratham versus P.S. Ranganatha 2008. In this case, it is held that contract which is not lawful, then the partnership is not the valid. Fifth essential is sharing of profit. Firstly, sharing of profit is a prima facie evidence and it is not the conclusive evidence. For example, there are the three persons A, B and C. Then they joint family and share the profit. Then it note that they are partners. There is a case, very two famous English case. First is Grace versus Smith and second is the Vogue versus Carver. In both the cases, it held that sharing of profit means also sharing the losses. Section 239 of the Indian Contract Act, it said that sharing of loss is mandatory, but it is repealed under 1932 Indian Partnership Act. Then there is a very leading case law, landmark case law, Cox versus Hickman, 1860. In this case, it held that sharing of losses is not mandatory, but there must be a subject to agreement according under section 13. Fifth essential is the mutual agency. It said that mutual agency is a conclusive proof, but it is not a prima facie evidence. Then there must be a act behalf of the other, and all are bound of that act. Section 25 of Partnership Act, it said that every partner is liable jointly as well as severally for act of firm. Then section 6 of the Partnership Act is that mode of determining existence of partnership, that there must be a three features: facts of circumstances of the case, terms of contract and intention of the parties. The if the these three things, it define that there must be an existence of partnership or not. Then principle laid down in the Cox versus Hickman, it said that tension between parties and the relevant facts said that the persons are partners or not. Persons having a joint or common interest in the property, it said that it means they are not the partners. There is a case, Govind Nair versus Maya, 1948. In this case, there are two persons who has purchased the tea shop and utensils, and then they give the shop to lease, and they equally share the rent, but it not means they are the partners. So a joint or the common interest in the property means not that they are the partners. नेक्स्ट वीडियो में हम कवर करेंगे काइंड्स ऑफ पार्टनरशिप एंड राइट्स एंड ड्यूटीज़ ऑफ पार्टनर्स. अगर वीडियो पसंद आए तो प्लीज़ लाइक करें, शेयर करें एंड सब्सक्राइब करें. थैंक यू.